All right, let's jump right into this explainer. Today we're unpacking a really fascinating legal cautionary tale. It's about a totally mundane municipal bill that somehow managed to escalate all the way up to South Africa's highest court. Seriously, this case is a masterclass in why you should never, ever decide that the rules of the court just don't apply to you. So this is the story of the Municipality of Plettenberg Bay versus Dyk Co Inc. It's a story packed with bureaucracy, sheer audacity, and ultimately the heavy cost of hubris.
It all kicked off with an unpaid municipal bill. And we're not talking about some massive infrastructure project here. The invoice was for exactly 69,684 rand and 74 cents. This was for professional services rendered to the municipality by an entity called Dyk Co. Now, in the grand scheme of municipal budgets, let's be real, this is practically pocket change. It is definitely not the kind of high-stakes, multi-million rand dispute you'd ever expect a government body to stubbornly drag all the way in front of the Chief Justice of the Constitutional Court. Yet, this incredibly exact, kind of petty figure is exactly what sparked a massive legal standoff.
But here is the massive twist in this whole dispute. Usually when a bill goes unpaid, it's because someone is claiming the work wasn't actually done, right? Or maybe the quality was terrible, or the price was just completely outrageous. But here, no way. The municipality didn't deny receiving the services. They didn't dispute that the work was actually completed. They fully, happily accepted the benefits of those services. And get this, they didn't even try to argue that the roughly 70,000 rand charge was unreasonable. They got the service, they kept the benefit, and they literally just decided they didn't want to pay for it.
So, instead of debating the actual quality of the work, the municipality decided to hide behind a technicality. They argued that their very own employee, the exact person who gave the instructions to Dyk Co, actually lacked the formal authority to hire the firm. They pointed straight to Section 58(1) of the Municipal Ordinance, claiming that a special council resolution was required to delegate those kinds of powers. Because there was no formal written resolution, the municipality argued the whole contract was just a complete legal nullity. It didn't exist. Meanwhile, the respondents' reality was so much simpler. Hey, we did the work and you accepted the benefits. So basically, the municipality was trying to weaponize its own internal bureaucratic oversight just to score some free professional services. While the High Court in Cape Town, where this whole mess started, was absolutely not having it. They shut down the municipality's defense by applying something called the rule in Turquand. Now, if you're not familiar, this is a long-standing legal principle that's basically a safety net. It's designed to protect outside parties who contract with an entity in good faith. Basically, it means if you do business with someone who clearly appears to have the authority to make a deal, which the law calls ostensible authority, you aren't required to play detective. You don't have to go digging through their internal company or municipal resolutions to make absolutely sure every single bureaucratic box was checked. The High Court ruled that the employee definitely had ostensible authority. And because of that, the municipality was legally estopped, meaning legally prevented from dodging the bill. They were told to pay up.
But refusing to just accept defeat and pay what was a relatively small debt, the municipality decided to appeal. But they didn't just appeal normally, like through the standard channels. Oh no, they tried to leapfrog straight to the Constitutional Court of South Africa. And in doing so, they made a really, really fatal procedural mistake. And to be clear, this wasn't some minor accident or clerical oversight. It was a conscious, deliberate decision to bypass the established rules of the highest court in the land.
So to appeal directly to the Constitutional Court at that time, there was a very specific procedure you had to follow. Constitutional Court Rule 18.2 explicitly laid out the exact steps. Step 1, apply to the High Court within 15 days. Step 2, obtain a special certificate of leave from that High Court. And only then, as Step 3, could you actually take your appeal directly to the Constitutional Court. This was the mandated pathway. No exceptions, no shortcuts. Now, you might be asking, why does this certificate even matter? Well, it wasn't just useless bureaucratic red tape. It actually served a really vital function. It was specifically designed to validate if the matter even had enough substance to require the Constitutional Court's attention in the first place. It confirmed whether the evidence on the record was sufficient for the higher court to actually dispose of the matter. And most importantly, it assessed if the appeal actually had a reasonable prospect of succeeding. It was essentially the High Court handing the Constitutional Court a roadmap and a recommendation, which saves everyone a ton of time and resources. Unbelievably, the municipality completely, deliberately skipped applying for this certificate. When they finally submitted their paperwork to the Constitutional Court, they essentially asked for condonation, which is basically just a fancy legal term for asking the court to forgive them for breaking the rules. And their excuse?
You're not going to believe this. They boldly stated that because the High Court had previously refused them leave to appeal to the Supreme Court of Appeal, they just naturally assumed the High Court would give them a negative certificate anyway. So they decided that following the Constitutional Court's explicit rule would be a, quote, waste of time and money.
I just want to let that sink in for a second. We are talking about a local government body here, an entity whose entire existence is based on creating, implementing, and enforcing rules and ordinances on its own citizens, and they decided that skipping the line and flat-out ignoring the Constitutional Court's clear procedures was perfectly acceptable simply because it was inconvenient for them. I mean, the sheer irony is just staggering. They were totally fine using a strict, ultra-technical interpretation of their own internal rules to try and weasel out a paying a bill, but then they blatantly ignored the explicit written rules of South Africa's highest court. So how did the Constitutional Court react? Naturally, they had to issue a response to this blatant, conscious disregard for their procedures. And spoiler alert, they were not amused in the slightest. The judgment delivered by the court, which was agreed upon by an incredibly impressive bench, including Chief Justice Chaskelson, was swift, sharp, and deeply, deeply critical of the municipality's behavior.
The court immediately called out the applicant's hubris. They wrote, "The applicant deliberately chose not to comply with Rule 18.2 because it considered that the rules served no purpose in the circumstances of this case." The court noted that this was a frankly terrible miscalculation. In fact, compliance with the rule would have served a massive purpose. It would have resolved ongoing messy disputes about whether certain constitutional arguments had even been properly raised back in the High Court in the first place. By completely skipping the certificate, the municipality actively deprived the Constitutional Court of the High Court's vital context and views.
The judges systematically dismantled the municipality's excuse. They stated it so plainly, saying there are no good reasons why a deliberate non-compliance with a rule of court should be condoned. The court really emphasized the context of the case here. Let's remember, this wasn't some life or death situation. It wasn't an urgent infringement of fundamental human rights where bending procedural rules might somehow be justified to prevent a grave injustice. No, this was literally just a money dispute over a relatively small bill for services they admittedly benefited from. There was absolutely zero urgency preventing them from following the rules.
And this quote right here brilliantly illustrates the ultimate legal smackdown. The court declared, "While the rule exists, it is the applicant's obligation to comply with its terms and not to question its relevance and ignore it as being of no value." Basically, you cannot simply ask for forgiveness instead of permission when you're dealing with binding court procedures. You don't get to just audit the rules of the Constitutional Court and decide which ones you feel like following on any given Tuesday. The rules are the rules, period.
So the conclusion was inevitable. Because there was absolutely no compelling reason to excuse this highly conscious decision to bypass procedure, the Constitutional Court dismissed the application entirely. And to add a final painful sting to the municipality's wallet, they didn't just dismiss it, they actually ordered the municipality to pay the legal costs of the application. An attempt to save roughly 70,000 rand, driven entirely by technicalities and pure arrogance, ended up costing them significantly more in legal fees, not to mention the massive public embarrassment.
We often look at bureaucratic rules and court procedures as just tedious red tape. But when a government entity, armed with a team of lawyers and vast resources, is punished so decisively for trying to bypass the system, it really begs the question, are procedural rules ever truly just suggestions, or are they literally the only thing keeping our legal system from collapsing into total chaos? Definitely think about that the next time you're tempted to cut a corner. Thanks so much for joining me on this explainer, and keep questioning the mechanics of the world around you.